Well, good afternoon, everybody. We've still got a few people logging on, so we'll give them just a minute or so to do that. Our subject this afternoon is protection and indemnity insurance. Your host today is me, Ian Greenway of LIG Marine Managers. Looking through some of the names of people logged on, I do recognize many of you, and for those of you who know me personally, I'll say hello. If you don't know me personally, I'll still say hello, but we'll go from there. In case anybody is not aware of my background, I am a Englishman, but I moved to Florida, which means I will be unavailable from 3 p.m. tomorrow afternoon for a couple of hours at least. There's some little football match or soccer match, as you might call it, going on at that point. Just to give you a heads up, we've got about 4 more webinars planned for this year. We'll publish the dates as we get closer to them. The next one is due to be common endorsements to marine liability policies. I always like to say it's good to read a marine liability policy from the back because you see what's been taken out by the various endorsements. So that's a really powerful seminar and can give you some good information. Mark Greenway is going to present MEL and subcontractors under an MEL policy, Maritime Employers Liability Policy. And then I'm going to do one called 7 Critical Secrets. These are some of the things that can go wrong in marine insurance and some of the things that perhaps some colleague agents have had E&O problems with or claims problems with in the past. Again, our subject this afternoon is P&I. We seem to have probably most people on, so we'll get going on the afternoon. One other final piece of admin, Q&A. I'll take a question and answer session at the end of the meeting. There should be in the top bar of your Teams meeting a little section that has a question mark on it called Q&A. If you'll click on there and type your questions in there, I should be able to see them as we go through the meeting, and do go ahead and put the questions in as you think of them rather than waiting for the meeting to end. But we will come back and answer as many as we can within the allotted time at the end. So maybe one of you would like to just put in a test question just to make sure it's working properly. We did have a minor hiccup with it last time, just to make sure it's working. So P&I, or Protection and Indemnity Insurance, it's a strange title. It doesn't really describe what it does. It's just a set of historic words, which I won't bother you with the history of why they came about, but it is the standard form of liability policy arising out of the use or operation of a watercraft. It's a little bit beyond sorry, I got the wrong thing. It's a little bit beyond the pure liability, a general liability policy, or even similar to an auto liability policy, because it gives you an element of coverage for workers' compensation. We'll talk more about that a little bit later on. But really, if you have a member, an employee that's working on board a vessel, owned or non-owned, you have liability to them under, amongst other things, I think called the Jones Act. So you're getting when you write P&I insurance properly, you're getting this package of third-party liability and workers' compensation or employee injury type of claims in one go. There are 3 forms very much in common use today in the commercial market. We're not going to deal in this particular seminar under the yacht forms. They're very, very different. Each company has their own. But in the commercial market, you'll see these 3 forms. The SP23, that is now 43 years old, if my math is any good. So it's a fairly dated form, but it's used very extensively. The SP38, that one dates back to 1955. So it's got its white hair and whiskers on. It's an old form. It's a very narrow form, and consequently Not many people like to use it. Maybe some underwriters do, but if you're an agent or a broker, it's not a form you want in most cases. And then the AIMU P&I form, interesting enough, also a 23. Not quite sure why though. The first and last forms are both 23, and they were both authored in 1983. So again, 43 years old today. So these forms have been around, and their historical counterparts have been around for some 300-400 years. So they're pretty tried and tested, and they do provide most of the coverage you need for the liability out of operating a vessel. Every one of these forms covers automatically loss of life, injury, and illness. And the question is, to whom? The 23, SB 23, is any person excluding employees under a Compensation Act. Also specifically provides for liabilities for stevedores handling cargo. The SP 38 is a little differently worded. It's any person excluding any claim under Longshore or workers' compensation. And again, the AIMU form follows pretty much to the letter, the SP 38 form. This doesn't exclude employees altogether. Our crew are going to get crew benefits. Again, we'll talk a bit about that a little bit later. The Jones Act, which is actually really called the Merchant Marine Act of 1920. The Jones Act is probably the most well known of these, but there are actually 5 different types of benefits a crewman can claim. And all these policies, unless they've got a crew exclusion added by endorsement, cover those types of injuries. If that crewman also has some duties ashore, could be loading or unloading or repairing the vessels, it could be I don't know, doing some work in an office or something like that, you may also need Longshore or state workers' compensation for them. But again, their crew activities are covered under this loss of life, injury, and illness. And again, if you look at most workers' comp laws, they have very little coverage for any illness. Whereas in the marine world, basically, if somebody becomes sick, one of your employees becomes sick when they're working on a vessel, you get to cover them for that sickness. Passengers, people on other vessels, people on land, dock, and again, crew. We've already talked about the crew part. But again, you've got a passenger vessel, a ferry boat, a cruise ship, little cross-river ferry. People on other vessels, could be you run into the next vessel and you injure people on there. People on land dock, you're running a boat and you hit a dock, and there's people on that dock and you injure them. The nice thing about all 3 of these policies is it doesn't matter who that person is. It's anybody other than those workers' comp Longshore employees. So I mentioned there are 5 different remedies for crew. Maintenance and cure is a no fault. The maintenance is a cost of living payment, typically $50, $75, $100 a day that's paid automatically. Cure is medical expenses. We get unseaworthiness, the Jones Act, the Death on the High Seas Act, and wrongful death. Let's look at each of those in a little bit more detail here. Maintenance is food and lodging. It's theoretically the actual expenditure of food and lodging until their maximum recovery or maximum medical improvement. It doesn't typically work that you have to send the bills in for your hotel room or your apartment and your lunch at McDonald's or wherever it be. Again, it's usually a fixed daily rate. Cure is medical services, so whatever your medical expenses are for the injury or illness that you contracted are all covered with that. Unseaworthiness talks about there's a defective condition of the ship or its equipment, and it goes through there all the different types of equipment that could be. It doesn't mean that it's going to have to, the vessel's going to sink. It could be something as simple as a winch didn't have the proper cover on it. There was a claim for unseaworthiness where there was water on a deck. I always thought that was a little bit of a stretch. It seems very odd on a ship that you wouldn't have water on a deck at some point in time. There was a claim by a young lady who was working on a crew boat. She was given a ladder to climb up to the top bunk to make that bunk up. And she claimed the vessel was unseaworthy because the ladder wasn't fixed and fell back when the vessel hit a wave and threw her off the vessel. Unseaworthiness, again, it doesn't have to be that the vessel's going to sink. It's just not right for what it's doing. A vessel that might be able to go across some small lake is hardly going to be the same vessel that could go across the Atlantic. If all you're using that vessel on is a lake, it could be fine. But if you want to sail it from Miami to England, that vessel could well be deemed to be unseaworthiness for that voyage. Legal remedies for crew. The Jones Act is one that allows the employee to sue his employer for his illness or injury. And due to the negligence of his employer. This test is a very light test. They call it a featherweight test. So it's really up to the crewman or the employer to prove there was no negligence rather than the other way around. One of the claims under this, which again I find rather a stretch, but was a gentleman slipped on a fish on a fishing boat. It's what you would hope there would be on a fishing boat if they're going to stay in business. So was the employer negligent because they didn't take that fish out off the deck? There's an argument that unfortunately would never win in court. But I think in moral terms, you would expect there to be fish on a deck of a fishing boat. So it's absolute, non-delegable, and includes the ship even if the employer is not the owner of the vessel. And that's a really important phrase I've got at the bottom of this slide. It doesn't matter who owns the vessel to be able to get Jones Act benefits. Think of a cruise ship. We've got thousands of crew aboard on some of these bigger cruise ships today. Many of them are not employed by the cruise ship line. They're employed by subcontractors or what they call concessionaires in that market. The dancers, the entertainers, the photographers, the tour guides are subcontractors to the cruise line in many cases. And yet whoever employed those people is the one responsible for the liability on the vessel. It doesn't matter whether they own the vessel, they operate the vessel, they have any relationship other than maybe a contractual relationship to be aboard the vessel. We have Death on the High Seas Act. Here we don't even have to prove we're a crewman. It applies to everybody. It starts 12 nautical miles, which is about 13.5 land miles out to sea. And it's monetary damages. There's no punitive damages. There are on unseaworthiness and Jones Act potentially punitive damages. This sort of overlaps the other two. If you've got a death on the high seas, you may well have a Jones Act case. You may well have an unseaworthiness case as well. And many of the suits you see are a combination of these. Again, this does not apply in US territorial waters. This is only once you're outside. That is unique to this particular act. It's not common. Jones Act can apply inside or outside. Unseaworthiness can apply inside or outside US waters. Wrongful death, I was always surprised that this took as late as 1970 to be established. This is sort of the mirror image of the Death on the High Seas Act. So if you can think of that 12 nautical mile line that goes around the United States, its territories and possessions, and Hawaii and Guam and all those other strange places. If you think of that line, outside of that line, you've got Death on the High Seas Act. Inside that line, you have wrongful death. Very similar statutes. There is it has to be a seaman or a passenger for this wrongful death. But they're very similar statutes. One just applies in one location, one applies in the other. Nobody's ever quite worked out if you die exactly on the line which way you go. I guess the courts will just take both and compromise from there. On top of our liability to people and to crew, we have damage to other vessels or property caused by collision. We're not going to deal with it in this particular seminar too heavily, but the hull policy, a traditional hull policy, covers primary collision liability. And what these three forms all do is cover the excess collision liability, except the AMU form. It's not in the basic form. You have to add it by endorsement. I'm sorry, no, that's true for the SB 38 as well. They don't give you that collision liability. SB 23 gives it automatically, excess over the hull policies. For 38 and the AMU form, you've got to endorse it to get collision liability. Collision is vessel to vessel. We're going to talk about a thing called allision in a moment, but this is collision. Collision is one vessel hitting another vessel. It could be a big cruise liner hit by a rowing boat, probably the other way around, but it doesn't matter what size or type of vessel it is, but these are vessel to vessel coverages. And this is physical damage to that third party vessel. So I'm running that tugboat down the river. I run into somebody else's ferry boat. I damage that ferry boat. The physical damage is covered under this section. Again, hull policy first, then the liability policy, the P&I policy second. This is the not caused by collision. And when we're doing live seminars, my conversation always goes, well, how do you damage the vessel without colliding with it? And there's really three types there: fire and explosion, wave wash, and running somebody aground. We also call it taking the channel. You've got a vessel coming towards you in a narrow channel. You plow down the center of the channel. That vessel has to veer off to avoid a collision. You have a liability to have that vessel for the damages to that vessel. And that is automatically included in all these policies. Same with wave wash. You're running it down and you've got a high-speed boat, you've got a big wave wash, you flood another boat that you're passing. Again, that's all covered within this, and obviously fire and explosion. This is allision. Some of you may recognize this little picture. It's the Key Bridge up in Baltimore, where the Dali ran into the Key Bridge. Was close to 2 years ago now, I think. This was the damage to this. And this is an allision. This is physical damage to something that's fixed. Could be a dock, in this case a bridge, be a pier, could be a tower. You can see there's a tower in the background of this picture. Anything that you run into that's not a vessel, not something that floats and moves, is covered under this section, automatically covered from whatever the deductible is on the policy up to the policy limit. It's always in commercial P&I forms. Wreck removal, again, not in the case of the Dali, but if your vessel sinks or is grounded in such a way that it's destroyed and you've got to remove the wreck, the P&I automatically covers that wreck removal. It is usually compulsory by law, and whatever's not already covered by any hull policy insurance, as you see on the 23. AIMU has a little add-in to that. It also includes attempts to remove. So if you attempt to remove it but fail, that's covered under the AIMU form, but not under the other two. Cargo legal liability. I've got a vessel that's carrying cargo around. Doesn't have to be a big ship. It could be something fairly small. You know, we've got a ferry boat up on the Great Lakes where they'll carry some small amounts of vegetables and produce from one place to another. They have a legal liability to deliver that safely. That's covered automatically in the 23. Includes baggage and personal effects if we've got passengers. 38 form excludes that absolutely. And again, AIMU form excludes that absolutely, but can be added back by endorsement. Just going to pause there for a moment again. If you've got questions, do please go ahead and post them in the Q&A, and I'll do my very best to answer as many as I can at the end of the webinar. Customs, immigration, or fines and penalties, SB 23 and 38 and AIMU all give you those coverages where appropriate. As you see, there's a highest degree of care for the assured and the managers. That's just really, if you did it deliberately, you're probably not going to get any coverage. But if it's innocently that you're fined or penalized, you get that coverage under the all three P&I forms. Cargo's proportion of general average. I'm going to get into general average claims here. That would take the rest of our time together and more. But a general average simply is that if one part of the cargo is damaged and they have to jettison it or do something that applies and helps save the rest of the cargo, there is a thing called general average, and everybody has to contribute even if your cargo wasn't damaged. Here we've got a cargo legal liability on the SB 23, and that also extends to give you that general average point arising out of the cargo legal liability. The 38 and the AIMU form do not provide those coverages. Limits, I'm not going to spend any real time on this. There's only one thing I would warn you about. If you get in here and start reading the SB 23 or the 38, it talks about an aggregate limit. And it's very misleading because the aggregate in this case is the aggregate of all the claims arising out of any one event. It's not a policy aggregate. If you have 4 claims under the policy, each of $1 million policy limit, you've got $4 million of coverage. But that 1 million applies to anything arising out of the one claim. It could be crew liability, it could be passenger liability, it could be collision, excess collision, it could be any one of those. Add all those together and you're getting what is really an occurrence limit. Again, the language of the SB 23 and 38 really dates back to the 50s. Even though 23 was rewritten more recently, they kept that same language. And again, it's not a policy aggregate; it's an occurrence aggregate. AIMU make it simple and call it combined single limit. That makes life nice and easy to read that particular one. SB 23 does not allow for a deductible. Virtually every carrier I know then adds that, but it's a separate endorsement. SB 38 does allow for deductibles. You have to complete one for body injury, one for property damage. You can write it in a way that's combined, but the 38 was designed for split deductibles. And then AIMU really follows the same as 38 and specifically says it includes costs and expenses, which again is pretty common in the P&I marketplace. I don't want to go through all these various endorsements here. I think most of them are pretty straightforward. Pollution, radioactive, punitives. Automatic acquisition clause is worth talking about. If you've got a single vessel, most underwriters won't give you an automatic acquisition clause. If you've got a fleet of 3, 4, 5, 10, 20 vessels, it's a great little clause to give you 30 days to report any new vessels. Most underwriters will set the limit of that automatic acquisition clause as the highest of the schedule you currently have on the policy. So if I got 10 vessels all valued between 100 and 500,000, I might get an automatic acquisition clause that says you've got 30 days to report to me any new vessel you acquire up to $500,000 of hull value, up to $1 million of P&I, whatever my maximum limits are under the current policy. Excess collision liability, again, 38 and the AIMU forms, you have to add that to get collision liability in excess of the hull. Excess Towers liability, that's towers, not towers. This is I'm towing a vessel. I could be just doing it occasionally, but this is more common for a tugboat. I'm going to tow or push a vessel around. I have a liability to that vessel, pretty well similar to the collision liability, but it's to the one I'm towing. Navigation warranty, again, watch out for this. You know, you might see one that says not more than 1 mile offshore, and your vessels are going 3 or 5 miles offshore. You're in breach of the navigation warranty there, so you want to be very careful with that one. Swimming and diving exclusions. You see this mostly on charter boats and other recreational type boats. You're going to see swimming and diving exclusions. War TRIA. In personam liability, what that does is allow a suit against a vessel, which is actually an in-rem suit, and a suit against a person, could be a corporation or an individual, to be treated as if they are the same. It effectively adds individuals who might own or have an operating interest in the vessel in as additional insureds. Additional insureds list, tankerman's liability. You might have a fuel boat that's going to go out and fuel other vessels. You have a liability for fueling the tankerman's liability. Dredge cause, crew warranty, named crew. I've got to spend a moment on named crew. This is a really dangerous endorsement. We see a couple of carriers use it, particularly on high speed or unusual vessels that have a named crew warranty. And you got, you know, Freddie and John, Jill, Jane as your named crew. Well, that's fine. But what happens when John is sick and we have to go and bring in a replacement crew? If you've got that named crew warranty, then you've got trouble, unless you go to the carrier and have that person endorsed on. One way to somewhat mitigate that is to use a position rather than the person. Named crew might be captain, deckhand, engineer, first officer. That way you're not worried about individuals, but you are limiting the coverage to some degree. And then lastly, voluntary wreck removal. Again, the wreck removal you get in the P&I form is compulsory. The government, usually the US Coast Guards, come in and said, get your wreck out of there. This is voluntary. We just decided we wanted to get it out of there. You get P&I forms for builder's risk. We're going to build a vessel. It builds in some P&I for sea trials and demonstrations. Club rules, these are for the ocean-going vessels. The P&I clubs that work across the world have about 80%, 90% of the world's tonnage. All the big cruise ships, all the big liners, all the big container ships, tankers, anything like that are in one of the P&I clubs, and they have a unique set of rules. It's like a policy, but it's very much a membership type of organization. And again, as I said at the beginning, boat and yacht policies all have their own sets of rules and terms. It's impossible to go through and compare all of those, because for the 50 companies that write boats and yachts, there's probably 100 different forms. I know at least of 4 different forms in Lloyd's, for example, for boats and yachts. So we'll come to questions. If you've got questions, throw them in that Q&A box. We did have a little issue last time that I was not seeing the questions pop up as they came up. So calling on my monitors to tell me, are there any questions that I'm not seeing?
There are. There's at least one.
There's at least one. We'll start with one.
Let's start with this one. Why do many carriers move the collision liability from the hull form and put it on the P&I form? Great question.
Great question, yeah. I used to teach with an underwriter, a long-term underwriter, for many years, and we did a sort of point counterpoint on this. The underwriter's argument on that is it's simpler to move the collision or the towers and all the towers liability from the hull onto the P&I policy. And I can't really argue with that point. It is certainly simpler, but as a broker or an agent, I would always argue against it, because you're giving up limit. Let me try and explain this. I'd love to be able to do a whiteboard at this point, but I don't have that technology in front of me. Let me try and explain this with some numbers. Let's say we've got a vessel that's valued, let's say $600,000, and we got a $1 million P&I policy. And we run into a ferry boat where we injure some people, injure some crew, and do physical damage to the crew boat, the ferry boat, I'm sorry. If I've got everything in the P&I policy, the maximum I can pay for that loss is $1 million. Of course, I might have some excess coverage, but within that primary $1 million, that's all I've got. If my collision liability is still in the hull, I've got $600,000 of collision liability in the hull policy, and then I've got another $1 million to spend out of the P&I. And that P&I could go for bodily injury or excess collision or crew liability. You know, you've got a lot more limit available if you keep it in the traditional way of hull in the hull covering the primary collision and P&I covering the excess collision. I think it's why, in reality, a lot of underwriters like to combine it because they're actually capping their liability for the claim for $1 million. When you spend that $600,000 on collision in your hull policy, you've still got $600,000 worth of coverage on your own vessel. In fact, when you do the hull seminar, you'll find there's 5 separate lots of limit available. So that hull policy with a 600,000 limit potentially could have a claim of 3 million. It's tough to see how that claim could really occur, but at least in theory, you've got 5 lots of 600,000 to spend on different types of elements of a collision claim. So brokers, agents try and keep it traditional, keep collision, primary collision in the hull policy, and P&I will come in and do the excess policy, assuming you've got it properly written. All right. Well, thank you very much. We ran 3 minutes over today, but I think that's probably good for this particular webinar. So we'll hopefully see you at the next webinar. If you're already signed up for this one, you will automatically get notification about 2 weeks before the next webinar is presented. Thanks for attending, and we'll look forward to seeing you next time.